The clerks. No, the order.
Oh, okay, yeah, the order.
Whoever's here on the weekend will usually put it in order for you. Denise, she speaks so great. She's like, it's okay. We'll do it. All right. Good morning.
Good morning, Your Honor. Mark Miller on behalf of Jenners Lopez. This is 2021 CF 8414AOX.
Yes, Mr. Lopez, you're here on a capias that was issued for your arrest for failing to appear for arraignment on a charge of possession of more than 20 grams of cannabis. Sorry.
20 grams of capias.
Yeah, 20 grams of cannabis. So there's no bond authorized on this capias. Your attorney is going to have to file a motion in front of the trial judge.
I'll explain that to you in a minute. Yes, Your Honor. I believe the trial judge is Judge Mark Bleckman in this case.
Give me one moment. Yes, it is.
Okay. Thank you, Your Honor.
All right.
We were
Yes,
just
sir.
retained late last night, so we'll get that bond motion filed ASAP.
All right.
Thank you so much, Your Honor.
Good luck, sir. Thank you, sir, for appearing.
That's all I have, Your Honor. May I be excused?
Yes, sir. Have a
Thank
nice
you.
weekend.
It's nice to see you. I hope you have a nice
Nice to see you as well.
May I approach, Your Honor?
Yes. And do this in between everyone for the court reporter. Mhm. Right. Good morning, sir. Please tell me your name.
Kenneth Brevet.
You're here in 21 CF 14612, charged with criminal mischief and battery domestic violence. There is probable cause. I'm going to appoint an attorney to represent you in this case. Give me one moment. So he was released from DOC in 2018? Is that right? Not probation. Okay.
Yes, Your Honor, and the assault DV from Osceola is a different victim.
All right. Give me one more moment. At this time, your bond is $1,000 on count one, $500 on count two. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. Were you two living together?
Yes, ma'am. I stay there now.
All right, so I'm going to order you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the
I
victim.
appreciate that. Yeah, that's all.
Yes, sir. All right, good luck, sir. Yeah.
Thank you, ma'am.
Yes, sir. And you can bring your stamp too. Oh, you don't have a stamp?
I do.
Seems prudent. All right. Sir, please tell me your name.
Gregory Mullins.
You're here in 21 CF 12689. The state has already filed an information in this case charging you with tampering with a witness to hinder communication to law enforcement and battery with a prior offense. I'm going to appoint an attorney to represent you in this case. Does either party wish to be heard on bond?
Mr. Mullins is entitled to a reasonable bond on this, Your Honor. That's all we would request from the defense.
Your Honor, state defense is correct. He is entitled to a reasonable bond. However, state would have you take into account his history. It seems like he has a fairly lengthy history of DV batteries, as well as the a failure to appear. However, it does seem like it was a long time ago. In addition to prior VOPs showing an inability to comply with court orders, in addition to out-of-state history showing he has potentially limited ties to the area. So state would have you take all that into account in addition to the facts that are alleged within this warrant.
At this time, sir, your bond will be $5,000 on count 1, $5,000 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Did the state file an announcement of no information on the false imprisonment?
No, Your Honor, we just filed information as to the bat one prior and the tampering.
I'm sorry.
Sir, you can say anything you want to say, but everything you say is being recorded and can be used against you later.
Your Honor, can you repeat the charges on the information?
Are these prior charges or are these charges as of now?
These are the charges that the state filed in an information that's currently pending against you.
And what were the two charges again, Your Honor?
It's tampering with a witness to hinder communication to law enforcement and battery with a prior battery offense. No, it's just on the warrant. Yeah, I guess so. Yeah. Sir, please tell me your name.
Jason Quinones.
21 CF 14634. You're here charged with child abuse. There is probable cause. I'll appoint an attorney to represent you in this case. Good morning, ma'am. Did you wish to testify this morning?
I'm just a maternal grandmother of the 12-year-old child.
All right. Is there anything that you want to tell me this morning?
Yes,
Okay, then hold on. First, I need you to raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I tell the truth, yes.
Thank you. Please state your name for the record.
Ivelisse McClellan.
All right, go ahead, ma'am. What is it you want to tell the court?
The daughter is in my home right now because she was afraid to go home. I have guardianship of her two older brothers, Mr. Quinones' older children. And I need to pick up some of her clothing. Because I've had her for 2 days, and also to pick up her computer at home so she could do schooling. She hasn't, she does virtual.
So this is really interesting. Ms. May,
Yes, Your Honor.
does the state have any ideas about that?
I don't know if that would potentially have to go through DCF, Your Honor. I don't, since this court doesn't have jurisdiction
I live in Seminole County.
over the witness that's here present today, the court can,
I have jurisdiction over the defendant, and I can order that he's not allowed to go back to that house.
Well, the girlfriend, he lives with his girlfriend.
He did. I can order him not to at this point.
Okay, so would she be staying with his girlfriend?
Who's she?
Edwina Orlet?
No, who?
Oh, I'm sorry.
Are you talking about the child?
Yes, I would like to know if the child could stay in our care till all of this is all settled.
So I can't, I don't have jurisdiction over any of that.
Okay.
I'm assuming that DCF was already contacted.
Mm-hmm.
They were, and what I'll order is, Mr. Quinones, that you'll have to comply with any plan set in place by DCF.
Mm-hmm.
But I don't have jurisdiction over anyone else in this case except for the defendant.
Okay, because I'm just saying that I have his daughter or whatever. She's a little banged up, you know. She has ringing in her right ear. I mean, we met with Orange County Police and Seminole County. There's other issues at hand too that are happening besides.
Ma'am, can I have a word also, please?
Sir, please wait.
Besides the issue with Mr. Quinones and his daughter.
So, ma'am, this isn't a child custody hearing, and I can't do
No.
anything about
I
the
understand
child.
that. The thing is that she's been in my care for 2 days, and she has to go to school, and I don't want any problems or whatever because I don't know what's going on.
Right.
I just wanted to be able to pick up some clothing and pick up her computer because I know that this is being looked into. So
I think what I can't give you any legal advice either. What I will say is, if you think you need to take her to the hospital, you should do that.
Well,
if you think you need to call DCF, you should do that.
Yeah.
But what I'm going to do here is, sir, your bond is $50,000. You can have no contact with the victim or the victim's grandmother. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You cannot return to this scene other than one time to gather your belongings with law enforcement. Do you understand that?
Yes. Can I say one thing?
Just a moment. You also can have no contact with any minor child under the age of 18, and you must comply with any plan set in place by DCF. Now, sir, you said that you want to say some things to the court. I want to make sure that you understand everything you say is being recorded and can be used against you later. Do you understand that? Your attorney is standing right next to you.
I don't need an attorney. I just want to.
You have an attorney. I've already appointed one.
I don't think he has anything to say, Your Honor.
All right. So after speaking with your attorney, you don't have anything to say to the court right now?
I do have a question.
Go ahead, sir.
As far as the law is concerned.
Okay, no, you're not going to ask that. Don't say anything.
Well, I did choose to represent myself, so I don't need an attorney. Well, ma'am, okay, I don't have any priors. I've never been accused of child abuse, and reprimanding your child for behavior is not a crime. And I'm just asking, please, I've been with my daughter since she was born, all the way up to this time. I've never had an issue with my kids ever as far as child abuse. Can you please give me a lesser amount for bail? And my daughter is not in any risk of her safety being with me. I've had her since she was a baby. I raised her by myself. I'm just asking, please have a little bit more leniency, please.
Sir, I read the affidavit. The allegations are incredibly concerning to the court. And despite what you're telling me, the information I have is that you do have prior convictions. The latest was in 2018 for battery causing great bodily harm, that you failed to appear for court at least 3 times. You've been arrested for robbery, home invasion with a deadly weapon.
Never convicted.
So at this time, sir, I'm not going to change this bond. However, I am still appointing the public defender to represent you. You can call them and they can file a bond motion in front of the trial judge. Good luck, sir. Thank you, ma'am. Good luck.
Thank you.
No, this one's just.
Good job.
3 times.
Please tell me your name. I'm sorry, one more time?
Reverend Richardson.
All right, Mr. Richardson, you're here in 21 CF 14635. A warrant was issued for your arrest, charging you with possession of a firearm by a convicted felon, grand theft of a firearm, aggravated assault with a firearm, domestic violence, and battery. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Just a moment. All right, sir, your bond on count 1 is $4,000. Count 2 will be $4,000. Count 3 will be $5,000, and count 4 will be $100. With special conditions, you can have no contact with any victim or witness in this case. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. I'll order you must surrender this firearm to law enforcement within 24 hours of your release. Were you living with the victim? So were you living together?
No.
Okay. Sir, you're going to have to maintain a separate residence at this point. I'll allow you to return one time with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand? All right, good luck, sir. Please tell me your name.
Marquise Gardell Dennis.
21 MM 7362. You're here charged with violation of a condition of pretrial release. A warrant was signed, so another judge has already found probable cause. I'll appoint an attorney to represent you. Good morning, ma'am. Did you wish to testify this morning?
Yes.
Sir, I need you to look this way. Thank you. Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Naija Arsalai.
I'm going to let the prosecutor ask you some questions, Ms. May.
Good morning, Ms. Arcelay. Can you please state your relationship to Mr. Dennis?
My boyfriend.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
Did you come to court back in October regarding the battery DV case?
Yes.
Do you remember at that hearing if you said you wanted contact?
I would like to drop the no contact order.
Do you have anything else you'd like to tell the court?
No.
That's all I have, Your Honor.
Thank you. Any questions from the defense?
No questions, Your Honor.
All right. Thank you, ma'am.
I have a question.
Yes, ma'am.
Where would I go to drop the no contact order?
So that's not the way this works. A judge ordered him not to have any contact with you. So the judge's order stands until that judge or another judge changes that order. As for prosecuting the case, that lies with the state of Florida. Currently, the state of Florida is prosecuting him. So it's not up to you to decide whether they're going to do it. It's up to the state. Now, Ms. May can give you a business card that has a phone number you can call, and you can go to the state attorney's office and talk to them about it. But it's up to them whether they're going to pursue the charges or not.
All right.
However, as I said, the judge's order stands no matter what. So he can't have any contact with you, even if you want to. He's not allowed.
Okay.
Hold on one moment. I don't think that's going to pull up. I don't know what this error message is. Do you have this up, Madam Clerk? Can you pull this?
Do you need the affidavit, Your Honor?
I don't want the affidavit. I want the no contact order. Which judge signed it?
It was signed by Your Honor.
That's what I thought.
Yes.
I thought I remembered this case. So, Mr. Brands, you know that my next question is going to be for you. This court has previously ordered your client not to have contact with the victim. Your client, however, in complete disregard for the court's order, not only had contact, but violent contact with the victim. So, what reasonable conditions of bond can you propose that this court can place on your client that he will comply with this time, given this is the same judge that ordered him not to do it last time?
Yes, Your Honor. He is entitled to a reasonable bond on this charge, unless there's a pretrial motion for detention. You can order certain terms that aren't included in a general injunction. You can order a curfew, have the client relinquish any and all weapons, and you can have them call in to a pretrial supervisor and give them a schedule where they'll be and when, done routinely with those on community control. But because this isn't a punishable by life offense or a pretrial detention motion, I would still have you set a reasonable bond on this.
And what do you think is reasonable, again, given this court ordered your client to do something and he, with flagrant disregard,
I have something
didn't do
to
it?
say.
Your Honor usually sets a higher monetary bond to send the message and then reiterate the terms of the no contact order.
Well, it's not to send a message, counselor. It's because the purpose of the bond is to secure his presence for court and also to protect the citizenry of Orange County and the victim in this case. It doesn't appear there is anything this court can do that will protect this victim. That's the court's concern.
I understand, Your Honor, but the state needs to file a pretrial detention motion to hold
I have something to
hold
say.
him here no
Just a
bond.
moment, ma'am.
I know you're referring to the statute of variables in protecting the community and the victims, but that has to be read together with the pretrial detention rule and criminal procedure.
What says the state?
Your Honor, in regards to counsel's argument, we've had this argument several times, and that there's 3 ways the state can hold someone no bond, one being a PVL or a capital offense, one being a pretrial detention motion filed by the state, which we have not filed at this time. I don't believe we intend to. I haven't had any correspondence from the trial ASA on this case to file that at this time. And the third way is a violation of a court order, either an injunction or a DV, no contact order or BOP. If the court finds there's no reasonable conditions that this court can place on the defendant to ensure the safety of both the victim and the citizens of Orange County. At this time, state's just asking, not necessarily that you find and set him at no bond. I share the same concerns that the court has already mentioned, and that this case was, date of incident was 10/17. He was released with the no contact order, I believe on 10/18. So 1 day later, and then the alleged incident of that violated his pretrial release being on 11/7. The allegations within that affidavit of violation of pretrial release are concerning, and that they seem similar to the underlying VAT DV. And the underlying VAT DV, it was alleged that the defendant was going to kill her. He grabbed her phone and hit her with it, using the phone and the hands, and that she was fearful for her life, that the defendant was going to kill her. And the affidavit for the violation is alleged that the defendant had a gun on him and threatened to kill her. And they apparently were together at a hotel within Kissimmee.
There was no violent contact.
Just a moment, ma'am. Let her finish.
So this time, state's just asking for a much higher monetary bond. He does have a fairly limited criminal history, and no prior affairs to appear. However, he does have a prior VOP. And then in addition to this this violation of pretrial release, it is showing partially an inability to comply with the court orders. So state's just asking for a much higher bond at this time.
All right, yes, ma'am.
There was no violent contact, nor was there a gun around at all. So the statement my mom had made is a lie because of how she feels towards him. But as far as violent contact, there was none of that.
All right, thank you. Mr. Dennis, you keep raising your hand. Is there something you want to say to the court, keeping in mind that what you're saying is being recorded and can be used against you later?
I don't think he has anything, Your Honor.
I reviewed the warrant and the affidavit. The allegations are incredibly concerning to the court. Further, what concerns this court is, Mr. Dennis, I remember speaking to you. I remember explaining to you no contact. I think I recall you telling me that you understood what no contact means. However, based on this warrant, it is clear that you have no intention of complying with court orders. That's very concerning for the court. Not just for the victim's safety in this case, but the victim's family and the other citizens of Orange County. At this time, I find there are no reasonable conditions of bond I can place on you, Mr. Dennis, with which you'll comply. So at this time, you'll be held with no bond. Your attorney can file a motion in front of the trial judge. However, even while in custody, you may not have contact with the victim or the victim's immediate family. Do you understand that? All right.
We object to that decision, Your Honor.
Sorry?
The defense objects to that decision, Your Honor, for the
I
record.
understand. All right. Good luck, ma'am. Do we want to do this now? Okay. Have you guys spoken with corrections about your cases?
We have. I have.
Okay. Are we bringing theirs out soon?
Yeah, yeah, I don't know that they're going to bring my client judge to 30.
Oh, yours is 33 days. Yeah, they don't bring your client.
Yeah.
But, all right, are we bringing him soon? I'm ready when you guys are. I just hate for them to sit around.
Your Honor, in regard to the 33-day motion, state's ready whenever you are.
Okay, let's do this one, and then we'll move on to that. Good morning. Please tell me your name.
Manika Etienne.
21 MM 7980. Ma'am, you're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Good morning. Did you wish to testify?
Yes.
All right, please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Elias.
Go ahead, Ms. May.
Good morning, sir. Can you please spell your name for the record?
FENELON.
Thank you. And what is your relationship to Miss Etienne?
Can I ask you a question? Can I have someone who speak French or Creole?
Do we have a Creole interpreter, Your Honor?
Do we have? All right, so we're going to have to skip this one and come back because we're going to have to call the language line. We don't have an interpreter right now. So have a seat and we'll call.
He did ask for French or Creole. I don't know. French is easier to get.
I don't think so. I think Creole probably is because we have them more often.
Understood.
Okay. Do you want to do the 33-day motion while we wait for her client to come out? Good morning, counselor. Go ahead and put your parents on record.
Good morning, Judge. How are you doing?
Excellent.
Good. For the record, I'm Matt Boomershine. I'm here for Mr. Efrain Misla Fontanez. It's case 21 CF 013342.
All right, I have your motion. Give me just a moment to review it.
Thank you, Judge.
And what says the state?
Your Honor, state is asking that you grant the motion. State did file a notice of non-filing.
All right, I will grant that motion.
Judge, the proposed order that we sent over to you in advance listed the conditions of pretrial release that were assigned at IA. So I think our order duplicates what was previously ordered for his pretrial release.
That sounds right. I read that and it does look like what we would order. So I'll sign that order and your client will be released.
That's great. Thank you so much, Judge. That's all I have
Thank you,
this morning.
counselor.
Good seeing you. Have a good day.
Good to see you too.
Have a good weekend. Thank you, State.
Oh, we have a Creole interpreter on the line.
Oh, that was fast.
I'm sorry, counselor. It never happens that quickly. We'll get right to your client, okay? Let's go ahead and do the Creole interpreter because we have them on the line. Can I do this? Do I have a Creole interpreter on the line? Oh, okay. They open it. Good morning. This is Judge Gibson. Who do I have on the line?
My name is Marilyn. I'm the interpreter, ID 110216.
Thank you. Has the interpreter been sworn?
Not yet.
Please raise your right hand.
Do you solemnly swear and affirm to translate from Haitian Creole to English, from Haitian Creole to English to the best of your ability?
Yes, I do.
All right. Thank you. Sir, please raise your right hand to be sworn.
T'en prie, levez bras haut pour s'assurer.
Do you solemnly swear and affirm the testimony you're about to give shall be the truth, the whole truth, so help you God?
Est-ce que... Okay.
I heard him say yes.
Yes, me too.
I think before the translation came through. Okay.
Please state your name for the record.
OK, bon nous nom pour dossier.
Fédélon Elias.
Elio Elias. Nom c'est Marilyn.
Fédélon Elias.
Et le nom Elias.
Fédélon Elias.
Fédélon Elias. Nom c'est Marilyn pour parler pour.
Non, Fédélon. Fédélon. F-E-N-E-L-O-N. Fédélon Elias.
Oh, Fédélon.
Fénélon, N-E, Fénélon Elias.
Bakajoni. Félénon.
Fénélon, F-E-N-E-L-O-N.
Oh, Félénon. Félénon.
I have your name spelled as F-E-N-E-L-O-N. Is that correct?
Nous à F-E-N-E-L-O-N, c'est ça?
Yes.
C'est le nom.
Thank you.
Good morning, sir. Can you please state your relationship to Miss Etienne?
Bonjour, monsieur. Qui relation avec Madame Etienne?
Madame Etienne, c'est Madame moi, nous mariés ensemble.
Madame Etienne, Mrs. Etienne is my wife. We are married.
Are you afraid of her?
Est-ce qu'on peut lui?
Non.
Non?
Non.
Has anything like this ever happened before?
Est-ce qu'on va comme ça, jamais arrivé avant?
Yeah, ça arrive souvent.
Yeah, it is very often.
Approximately how long ago would you say the last time was?
Combien de temps ça fait de ça passé dernière fois?
Dernière fois, ça capable peut-être gagner 2 ou 3 weeks. 2 ou 3 semaines.
The last time it could be 2 to 3 weeks.
Okay, thank you. Do you believe drugs or alcohol were involved in this incident?
This is the interpreter. Can you repeat that, please?
Do you believe drugs or alcohol were involved in this incident?
Est-ce qu'on pense drogue avec alcool te combat pour ouais avec incident?
Non, li pas drogué, mais des fois li kon boit alcool.
No, she's not on drug, but sometimes she drinks alcohol.
Are you willing to call 911 if anything like this or anything more severe ever occurs in the future?
Est-ce qu'on a intention de les 911 si on bail comme ça t'arriver dans le futur?
Moi pas intention ça.
No, I don't have that intention.
And do you want to have contact with her while this case is pending?
Est-ce qu'on veut gagner contact avec lui pendant que ça en suspens?
Oui, c'est madame moi.
Yes, that's my wife.
That's all I have, Your Honor.
Any questions from the defense?
No questions, Your Honor.
Pas aucune caution de défendant.
Thank you.
Merci.
Ma'am, at this time, your bond is $500.
Eh bien, kounye a wagen pou payer une caution de $500.
With special conditions,
Avec des conditions spéciales.
you can have only peaceful contact with the victim.
Ou seulement ka genyen un contact en paix avec victime nan.
Do you understand what peaceful contact means?
Yes.
Est-ce qu'on comprend? Okay, yes, okay.
Yes.
You can't possess a weapon of any kind, firearm, or ammunition.
Ou pa ka gen aucun arme, aucun revolver à munition.
You can't possess or consume any alcoholic beverages.
Ou pa ka boire ou consommer aucun alcool comme boisson.
Are there any other conditions the state would request?
Est-ce que gen l'autre condition que l'État a demandé?
No, Your Honor. State was asking for no contact due to the victim's testimony.
Non, nous tap just demandé pas gen contact d'après testimony victime nan.
He testified, one, that this happens all the time. The last event was approximately 2 to 3 weeks ago.
Ou di sa arrive souvent et dernière fois ça passé gen 2 à 3 semaines de ça.
And he also testified that if anything like this or anything more severe ever occurred in the future, he would not be willing to call 911.
Et puis ou testifier tout si bagay ça plus sévère arrivé dans le futur ou pas prélé 911.
Due to those two statements, state is concerned for the victim's safety and would be asking for no contact.
So, est-ce qu'on connaît que pour sécurité victime nan, nous demander pour pas gen aucun contact?
What says the defense?
No argument, Your Honor.
Okay.
Can I have a question, please?
Yes.
Et yon nan bagay ke mte avle mande, mwen ta avle ke nou edel parce que li se yon moun, li pa violent, men li gen de problem psychologique des fois.
What I want to ask you, I would like to ask you if there is any way you can help her. She's not a violent person, but she has some psychological problems.
So I appreciate that, sir. Unfortunately, this court doesn't have jurisdiction to order any kind of treatment.
M'apprécier ça, mais malheureusement, la tribunal là pas aucune juridiction pour ce genre de traitement ça yo.
What I can do is ask Mr. Brantz, her attorney, if you can make a note for your colleagues, please, sir.
Yes, Your Honor.
Ça m'a demandé monsieur Brantz avocat là pour mettre tout petit note pour.
Okay, merci.
All right, I'll stay my order at this time. Thank you both, and good luck, sir.
Thank you.
Is there anything else I may help you with?
No, thank you.
You're welcome. Thank you for using our service. Au revoir, monsieur.
All right, counselor. Sorry for the wait.
Good morning, Your Honor.
Morning.
For the record, Your Honor, I'm Attorney Merrill Glover Gambles. I represent William Montanez Jr.
Mr. Montanez Jr., you're here in 3 cases, 20 MM 6876, 6875, and 5761. All 3 of these are violations of probation. It looks like warrants were issued for your arrest, authorizing no bond at this time. I can't read one of the affidavits. Give me one moment, see if I can open it this time. Oh, you have them? Oh, thank you. That's simpler. All right. Did you wish to be heard on anything in reference to these cases, ma'am?
Yes, Your Honor. I would like the court to allow me to offer testimony in regards to establishing a reasonable bond.
All right. Please proceed.
Please state your full name for the record.
William Montanez Jr.
And Mr. Montanez.
I need to have him raise his right hand to be sworn.
I'm sorry.
That's okay.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
William Montanez Jr.
Thank you. Go ahead.
Mr. Montanez, do you reside here locally? And how long have you lived there?
Yes. 17 years.
And what's your address?
6301 Hillwood Drive.
And you reside in that home with whom?
My dad.
Okay. And were you, you came here as a child and were you educated in the local schools?
Yes.
Do both your parents live here in Central Florida?
Yes.
Are you employed?
Yes.
Do you also have minor children who live in Central Florida?
Yes, with me.
Okay. And if the court saw fit to give you a reasonable bond, would you appear for all of your court appearances?
Yes.
Do you have a problem with them coupling a bond with pretrial release?
No.
Do you own any firearms or other weapons?
No.
Nothing further, Your Honor.
All right, thank you. Anything from the state?
No questions, Your Honor.
All right. Any other evidence, counselor?
No, Your Honor.
All right. Any argument?
Just, Your Honor, I do understand, at least we've heard that the allegation is that he made a single phone call to the alleged victim in this case. My client denies that, but I know we're not here for that. It's just that he has a business that he runs, and he really needs to be released, or you know, he'll have a place to live because he lives with the parents, but he's going to lose, you know, the things that he's established, Ron, while he's sitting in jail. He would agree to have absolutely no contact with the alleged victim. And as I said, he's not, he's been on probation, I believe, for the last 4 months. I handled the initial cases, Your Honor. He's completed the battery intervention program. He's complied with the other terms of his probation. And he just needs a reasonable bond so that he can contest this thing, but he can do that from outside, Your Honor. And I can have his assistance in defending him in the cases.
All right, thank you, ma'am. Anything from the state?
Yes, Your Honor. First, all three underlying offenses are violation of domestic injunction and violation of PCR conditions on domestic violence cases. The victim does have a right to be heard if bond is going to be set. But all three cases are DV in relation and all are on the same victim. He was sentenced to probation on 7/14/2021, so approximately 3-4 months ago. One of the conditions was that he have no contact with the victim. It is alleged on 9/24, so approximately 2 months after that was put in place, that the defendant had contact with the victim, according to the victim, asking her to take the restraining order off of him. The victim apparently hung up on him at that time, as she had both an active injunction against him as well as these 3 no contact orders in all 3 of these cases. Mr. Montanez has already shown to this court that he has an inability to comply with court orders. He violated the injunction, and the injunction that was final, as well as all 3 no contact orders. Also, in regards to his history, it does appear like he had 3 other violations of domestic injunctions. So state, we just ask for that you maintain the status at no bond currently. So this can be seen in front of Judge Shoemaker, and the victim will have a right to testify if bond then be set, if reasonable.
All right, thank you both. I reviewed the warrant signed by Judge Bain, and despite the testimony here today, ma'am, I'm not inclined to give your client a bond. The warrants have it set at 0 bond, and I believe part of the reason for that is the underlying offenses were violating conditions of pretrial release, and the allegation is that he violated his probation by contacting the victim. So at this time, I'm not inclined to do that. Sir, you're gonna have to wait. Your attorney's gonna have to talk to Judge Shoemaker about it.
Thank you.
Good luck, sir. Yes, ma'am. Thank you for coming. Please tell me your name.
Majesty Hall.
21MM545. Sir, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yeah.
You can't call her on the phone. You can't speak. You can't,
Correction. It's a male.
or him, I'm sorry.
Females.
You can't call him on the phone. You can't speak to him. You can't send a text message. You can't contact him on social media. You can't send a message through friends or family. So no contact at all. You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand? You have to answer out loud.
Yes.
All right, thank you. Good luck.
Your Honor, state's also asking for no contact with the witnesses.
I will order that you're to have no contact with any witness in the case.
Can I ask one question before I leave?
Sir, you can ask anything you want, but everything you say is being recorded and can be used against you later. Do you understand?
Is it a 10% of the 500 or is the whole 500?
So I can't tell you because that's between you and a bondsman. You have to call a bondsman, and that's who will make that arrangement with you.
One more question. Do I get released from right now?
If you post bond. Whenever you post bond is when you can be released.
This is all new for me. It's my first time being arrested. So
on that green piece of paper, sir, there's a phone number for the public defender's office. If you call, they can help walk you through everything.
Approach the clerk.
Okay. Please tell me your name.
Monica Horvath.
You're here in 21MM7988, charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim or any witness in the case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, a firearm, or ammunition. You can't possess or consume any alcoholic beverages. You must maintain a separate residence. I'm sorry. You can't return to the victim's residence for any reason. I show she's a violent felony offender of special concern and on probation.
Do we have any holds for her yet?
She has the VFOSC hold.
She has what?
VFOSC.
Right. So there might be a violation of probation warrant coming. I don't know. So, ma'am, call your attorney right away.
It's just not return and then no weapons.
No weapons and no alcohol. Good morning. Please tell me your name.
Soraya Johnson.
You're here in 21 MM 7983, charged with battery, dating violence. There is probable cause. I'll appoint an attorney to represent you. Good morning. Did you wish to testify today?
Yes, ma'am.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, I do.
Please state your name for the record.
My name is Zaki Beamer.
Go ahead, Ms. May.
Good morning, Mr. Beamer. Can you please state your relationship to Ms. Johnson?
This is my wife, and I'm her caretaker.
Are you afraid of her?
No, ma'am.
Has anything like this ever happened before?
No, ma'am.
If anything like
Just
this,
recently got out the hospital, so she's just upset.
understood. If anything like this ever occurred in the future, would you feel comfortable calling 911?
Do I feel comfortable calling 911? I never called 911.
If anything like this, or you ever felt threatened, would you feel comfortable?
If there's a threat, yes. But like I said, I'm no victim. I never called 911.
Understood, sir. Do you believe drugs or alcohol played a part in this incident at all?
No, ma'am. She doesn't do any drugs.
And do you want to have contact with Ms. Johnson while this case is pending?
Yes, this is my wife, and I'm her caretaker. We're not from this state, and whatever I have to pay to get her out, I will, and I apologize for wasting the court's time. But I'm no victim, and she's no offender.
Thank you. That's all I have, Your Honor.
Thank you, sir. Anything from the defense?
No questions, Your Honor.
In this case, does the state object to pretrial release?
No, Your Honor, but pursuant to the statute, state would ask for bond in conjunction with pretrial release.
All right, Ms. Johnson, I'm going to place you on pretrial release and require that you post a monetary bond. However, I'll reduce that amount significantly. It'll be $100. With special conditions based on the testimony here today, I'm going to allow you to have peaceful contact with the victim. No hostile contact. No pushing, no shoving, no hitting. Don't even raise your voice. Do you understand? You can't possess a weapon of any kind, firearm or ammunition. Yes, sir. Did you want to ask something?
No, I didn't want to cut you off, but I did have two things to say.
All right, go ahead.
I just wanted to know, I understand that I was told that it was under the Florida state law that I didn't have to necessarily go on record and say that anything happened with the officer. And I would like to have like some type of record on file saying that, I just was like, I didn't press anything or I didn't call them or this is, I understand, this is how it works down here, which I was told, but I'm no victim. And,
I understand.
Like I said, whatever I have to pay, I will, but she just had a stroke. And like I said, I have our service dog at the hotel and I need to get her out. I just caught the bus down here. I need to get her out.
So I gave her a bond of $100. It's very low.
Okay.
Combined with pretrial release. So she'll have to comply with those reporting requirements. But
because we're from Georgia, we're not from here. So I'm asking whatever I have to pay, I'll pay it.
I can't require you to pay. She has to post the bond. But if you do it on her behalf, you can do that.
Yeah.
It looks like what happened is someone else called law enforcement.
Yeah, I understand.
And in the state of Florida, battery is a crime against the state of Florida.
I understand.
So while you're the victim, the state is the one who makes the filing decision.
Understand.
So I'm sure Ms. May is making notes for her colleagues and she can give you some information so you can contact the state attorney's office.
Okay.
And they'll decide if they're going to file this or not. I can't tell you if they will or not.
Okay.
But
as long as I can, sorry to cut you off, Judge, as long as I can pay the $100, I can get her released today?
yes.
Okay. I appreciate it. Thank you a lot.
Yes, sir. Good luck. Good luck, ma'am.
Is Ms. Johnson able to return to Georgia if necessary?
Yes.
Love you, baby. I'll get you out real soon.
Good luck, sir. Please tell me your name.
Felipe Morgan.
Good morning. You're here in 21 MM 7976, charged with battery dating violence, and 21 MM 7977, charged with battery. At this time, I'm going to appoint an attorney to represent you. Give me one moment. There is probable cause in both of these cases. Your bond will be $500 in each case with special conditions. You can have no contact with either victim and with any witness in the case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with either victim. Do you understand?
Yes, ma'am.
Are there any other conditions the state would request?
There was an allegation of alcohol, Your Honor.
I will further order that you cannot possess or consume any alcoholic beverages. Good luck, sir.
Yes, ma'am. Thank you.
Yeah. I don't know why I gave it to you. Just to keep you on your toes. I can go that way. Yeah. Totally. As it should be. Please tell me your name.
Rita Nathan.
Good morning. In 21 MM 7989, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
No, ma'am, where am I supposed to go? That's my husband. I live there.
Right now, you can't. You can't speak to him. You can't call him on the phone. You can't send a text message. I'm going to order that you must maintain a separate residence, but I'll allow you to return one time with law enforcement to gather your belongings. You can't coordinate that with him, though. You understand? Until another judge changes that order. So you're going to want to call your attorney and ask them to file a motion in front of the trial judge. Also, you can't possess any weapons, firearms, or ammunition. Good luck, ma'am. I do have to send this too. No. Please tell me your name. 21 MM 546. Sir, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Give me one moment. Does either side wish to be heard on bond?
From the defense, Your Honor, I would just have you have straight bond, reasonable bond on this, Your Honor.
Your Honor, state would, again, asking for a reasonable bond as he is otherwise entitled to it. I'm assuming the reason the court is asking is due to his history. It does seem like he does have a violent history, at least here within Orange County. It does seem to be a little bit older. And I don't believe any of the prior offenses were against the same victim. Just say we just ask for a reasonable bond.
In this case, your bond will be $1,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes, ma'am.
Good luck, sir. Please tell me your name,
Swanette.
your full name.
Swanette Rodriguez.
You're here in 21 MM 7985, charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Good morning. Did you wish to testify?
Yeah.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Please state your name for the record.
Alexandra Manaya.
Go ahead, Ms. May. You may inquire.
Good morning. Can you please state your relationship to Miss Rodriguez Rivera?
She's my girlfriend.
Are you afraid of her?
No, ma'am.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yeah.
Do you believe drugs or alcohol were involved in this incident?
No, ma'am.
And do you want to have contact with her while this case is pending?
Yes.
And she qualifies for a program called pretrial release, meaning that she can be released on a low monetary bond, and be subject to that program. Does that sound okay to you?
Yeah, it's fine.
Is there anything else you'd like to tell the court?
Would I be able to release her today, or how does that work, or is it still pending? I don't know. It's my first time, so I don't.
I couldn't hear that. I'm sorry.
Is it? Am I able to bond her out today, or how does that work? Because that was my first time, so I don't know.
So I'll be giving her a bond, but whether you post it is up to you. I can't require you to do that.
Okay.
That's all I have, Your Honor.
All right. Anything from the defense?
No questions, Your Honor.
All right. Does either side wish to be heard on bond?
Your Honor, she does otherwise qualify for pretrial release. The state would have no objection to pretrial release with a bond subject to 907. The reason I state believes that she may be a good candidate for pretrial release instead of just straight bond is due to there were allegedly knives grabbed. I don't believe they were ever used in a assault type way. However, knives were grabbed. So I believe the extra supervision may be appropriate for this case.
We would just request straight bond, Your Honor.
All right, ma'am, your bond is $500. With special conditions, you can have peaceful contact only with the victim. No hostile contact. No yelling, no shoving, no throwing things, nothing. You can't possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck to both of you.
Thank you.
Good morning, sir. Please tell me your name. It looks like you have a warrant out of Seminole County for failure of registration. Oh, but it says no. Registration owner of vehicle to notify DHSMV of change. Failing to register a vehicle? Give me 1 second. It's out of Seminole County. There's a bond on it of $500. We'll notify them that you're here so they can transport you, but if you're able to post the bond, you can. And as long as there's nothing else holding you, you'll be released. It looks like it's 21 CT 2576. And in the meantime, I'll appoint an attorney to represent you. All right, good luck, sir. Oh, that didn't help. Please tell me your name. Sir, you have a warrant out of Jacksonville for violating probation on a charge of resisting an officer without violence. It looks like the case number is C1606909. There's no bond authorized on that warrant. I'll appoint an attorney to represent you and we'll notify them that you're here so they can transport you. Mr. Brands, I also see that he has a hold out of Palm Beach. So he might have another warrant. All right, good luck, sir. Yeah, it's just for you to see it. Oh. Sir, please tell me your name.
Christopher Zaguero.
It looks like you have 2 warrants out of Seminole County, 20 CF 1455, 21 CF 51, for violating probation on 2 charges of driving while license suspended. There's no bond authorized. I'll appoint an attorney to represent you, and we'll notify them that you're here so they can transport you. Good luck. Contact. That's why I wanted to see it on that one, because I knew I recognized him and I recognized that. And I sign it and he signed it. Please tell me your name.
Jackson Sibilis.
It looks like you have 2 warrants out of Seminole County for violating probation on burglary of a structure and illegal possession of a debit card. In case numbers 19 CF 3384. Oh, it's only 1 warrant. Sorry, it's 1 case. I see you shaking your head. You knew that. Sorry about that. There's no bond authorized on this. I'm going to appoint an attorney to represent you, and we'll notify Seminole County that you're here so they can transport you.
One question.
Yes, sir.
If my probation was transferred to Orange County, why does it still say Seminole?
Because Seminole County is where you were placed on probation, and so if the violation of probation was filed there, you have to go back to Seminole to answer to that judge. That's why. Please tell me your name.
Ricardo Pedraza Olmera.
Oh, you have a warrant for violating your probation in 19 CF 14557. Hold on one moment. There's no bond authorized. I'll appoint an attorney to represent you. And it looks like I can't open any of these. I don't know what's going on with my Odyssey, but I can't open these documents. Give me one moment. All right, the allegation in the warrant is that you used intoxicants to excess in violation of your probation. All right, good luck, sir.
Thank you.
It's not in here. It's not. Please tell me your name.
Renoir Amari Powell.
All right. In 19 CF 11918, you're here for violating probation. There's no bond authorized on that warrant. I'll appoint an attorney to represent you. In 21 CF 11882, you're here charged with carjacking. It looks like an information was filed. I'll appoint an attorney to represent you in that case as well. Did the state wish to be heard on bond?
Your Honor, given that it's only an F1, he is entitled to a bond on that case. State would just ask for a reasonable bond, and given that it is an F1, and he's already shown an inability to comply with court orders and does have prior failure to appear.
So which carjacking is PBO?
With a firearm or deadly weapon.
It's what?
With a firearm or deadly weapons.
Okay.
It's not charged as that way currently. Just a carjacking is an F1.
All right, on the carjacking, sir, your bond is $50,000. You can have no contact with any victim or witness in that case. Do you understand what no contact means? You have to answer out loud.
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. And you can't return to that scene for any reason. Then in 21 MM 7987, you're here charged with resisting an officer without violence. I'll appoint an attorney to represent you in that case as well. There is probable cause. Your bond is $500. Good luck. Is the state ready for the 33-day motions?
Yes, Judge.
All right. Who do you have first?
Jarvis Burton, 21 CF 13231, granted notice of non-filing. And Carrie Dubois.
Good morning. Please tell me your name.
Carrie Brantley Santel.
Hold on one moment. You're here in 21 MM 7978, charged with trespass on property after warning. Was there an offer in this case?
Yes, Your Honor. State conveyed an offer of an adjudication, credit time served, no return to the Emerald Villas apartments.
All right. Mr. Brands?
Your Honor, I had a chance to speak with our client, and we went over the terms of that deal as well as the terms of a plea offer and entering a plea, and I believe our client wishes to resolve that today.
All right, please raise your right hand.
Please solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God. Yes. Thank you.
All right, there is probable cause here. You can put your hand down. You had a chance to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes.
Do you have any questions for me about those rights? And you had a chance to review that plea form. It further explains those rights to you. Do you have any questions about that? You understand that if you're on probation anywhere, this plea could violate it?
Yes.
You understand if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
All right. At this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. What was the state's offer?
An adjudication, Your Honor.
All right. I will adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. Was there a no return?
Yes, Your Honor.
And I'll order that you're not allowed to return to the Emerald Villas apartments. Do you understand that?
Yes.
Thank you. All right. Good luck. You have 30 days to appeal in writing.
Thank you all. Thank you.
Thank you. Good luck. Yes. Because we see him all the time. Please tell me your name.
Ralph Watwood.
Just a moment.
Welcome to an Econo meeting. You are entering the meeting now.
All right, just a moment. We'll have to go back to that. So, if you have a private attorney who's on the list, you have to, I'll show you that. But this is how you get to our Cisco link. This is Judge Gibson. Do I have anyone on the line?
This is AJ Fowinkle.
Ah, thank you, Counselor. Good morning.
Good morning. How are you, Judge?
Excellent, sir. You're here representing Ralph Watwood.
I am.
This is 21 CF 36220. Mr. Watwood, you're here charged with violation of a condition of pretrial release. Mr. Fowinkle, I understand that you definitely wish to be heard on this.
I do. And I don't know if the court was able to get my email that I sent earlier this morning.
I got it, but I have not reviewed it.
Okay. The state attorney in this case, this case is in front of Judge Wooten. And Mr. Lentz is the assistant state attorney that's handling this case. He had no objection to when I was trying to have the warrant recalled. if you follow that email string, it shows that there's been new evidence that's been presented to show that allegedly, all right, nothing's been proven yet, but we were able to get a video from the parking lot of the Target where the victim alleged that my client battered her after being released on bond. And the video seems to, well, in my opinion, it absolutely refutes what she's saying. Provided that to the state attorney. He's been trying to talk with the officer, or the deputy, Deputy Silver, in this matter. Deputy Silver's been very, very accommodating both to me and trying to get in touch with the state attorney. State attorney finally talked with him last weekend. This has been a month-long process in trying to get this rectified. And finally, the state attorney said that he didn't have any objection to me recalling the warrant. We submitted that to Judge Wooten, I think on Tuesday of this week. And it just, and then it wasn't signed yet. And Mr. Watwood was picked up yesterday on Veterans Day as a 22-year honorable veteran. No prior criminal history. It just stinks. And the irony of that happening on Veterans Day just was Mr. Wildwood was pretty bummed about the whole situation. Since then, I've been able to talk with the state attorney again. Obviously, the motion to recall the warrant is moot since it was executed. I was trying to see if maybe we couldn't either, I don't know if you can, or if I just need to do it in front of Judge Wooten, to reinstate the bond under the original conditions. I heard from the state attorney, and that's when the email that I submitted to you this morning was his email indicating that he had no objection to the bond being reinstated with the original conditions based on this new evidence that sounds like, because the victim's credibility is compromised based on providing a false report, this case may be going away anyway. That's straight from the state attorney's email back on November 5th. But that hasn't happened yet. But you do have the email from the state attorney, Mr. Lentz, saying that he has no objection to the bond being reinstated. That's what I'm going to be requesting from you this morning. I just don't know if that needs to be done by Judge Wayne Wooten or if you have the ability to do that this morning.
I reviewed the court file, and because it's a warrant and not a capias, this court does have the ability to change the bond. Let me ask, Ms. May, did you see these emails?
I did not, Your Honor.
So I know that I have the email. Mr. Fowinkle did copy the state attorney on it, who is Garrett Lentz.
Your Honor, state would just asked that given that the defense attorney and Mr. Lentz have already had, it seems like extensive conversations about this, that this be heard in front of Judge Wooten, and we stay the bond at no bond currently for Mr. Fowinkle to file that motion for bond in front of Judge Wooten, so ASA Lentz can be a part of it, given that I don't have any other information on this case.
Just a moment. Do we have can you call the state attorney from that phone? I do. It's 1-407-451-3226. That's his cell. Lentz, Garrett Lentz. All right, try his office. 407, please. 836. Oh, sorry, because it's an office. Sorry. It's 2455. Oh, yes, can we put him on speakerphone? Well, let's just try it and see what happens. I've never tried to do this before. Mr. Fowinkle, sorry, I'm trying to see if I can get him on the phone.
Thank you, Judge.
Okay, let's see if it appears here. Ah. Good morning, this is Judge Gibson.
Good morning, Judge Gibson. This is Garrett Lentz from the State Attorney's Office.
Hi, thanks for taking our call. Sorry to disturb you in the middle of the morning, but I'm here with Mr. Fowinkle representing Ralph Watwood. And in 21 CF 36220, I saw the email traffic this morning, and I know that Mr. Fowinkle did copy you on those emails. He's asking the court to reinstate Mr. Watwood's bond because it's a warrant and not a capias. I can do that. But I wanted to get the state's position before I make a ruling.
Yes, Your Honor. The state's position is that it has no objection to a reinstatement of the bond with the original conditions in play. The reason for that is there is a discrepancy currently outstanding with the no contact violation that did occur. Currently, there is an investigation for a falsified police report that is outstanding regarding the incident that did take place. We're waiting. The state is currently waiting on the supplement report from Officer Silber regarding the incident, but after a conversation with him, it does look like there are some inconsistencies with what occurred that day. So given the confusion of the violation, the state has no objection to a reinstatement of bond with the original conditions.
All right, thank you so much. Mr. Fowinkle, was there anything else that you wanted to add?
No, Judge.
All right, Mr. Watwood, I am going to reinstate your bond with the original conditions. What that means is you can have absolutely no contact with the victim in this case. You understand that? Ms. May, just so you know, because of the email traffic here, I would normally have done what you requested.
Understood, Your Honor.
But I'm reading the emails and it just seems like there was a lot going on in this case, so.
Yes, I just wasn't privy to those emails.
Right, you don't have them, so I just wanted you to know, normally I would have done what you requested, but in this case, it's a little bit different. So, Mr. Watwood, after reinstating that bond, I just want to make sure that you understand, it seems like there's a lot of confusion in here, but the court definitely has jurisdiction over you and you can't have any contact with the victim. So even if you're somewhere and the victim shows up, if I were you, I'd go the other direction. All right? I'm sure your attorney will talk to you about that more, but good luck. Thank you for your service. And Mr. Fowinkle, thank you for your time. Mr. Lentz, thank you for appearing this morning.
Yes, thank you, Judge.
Your Honor, the original bond was 1,000, correct? I believe so.
Do you know what it was, Mr. Fowinkle? I feel like that's right.
I think there was 1,000, but I'm not 100% sure on that.
Hold on. I think I can look it up. It might say it on this.
That's what I have on the clerk's site, Your Honor. I believe that's correct.
Okay, 1,000. Yes. All right. Thank you both.
Thank you, Judge. That's all, if I may be excused.
Yes, sir. Have a nice weekend.
Thank you. You too.
Your Honor,
Yes.
Burden Christopher refused.
All right. Was that Mr. Lentz disconnecting? Yeah. Okay. So Mr. Burden has 21 CF 14613. At this time, I'll find his refusal a willing waiver of his appearance today. I'm going to appoint your office, Mr. Brantz.
Yes, Your Honor. Thank you. The only challenge I would have is on the, I believe, count. Oh, was there a charge of a stolen firearm?
Yes.
Grand theft of a firearm?
Count
Yes.
17.
17. As to the probable cause on that, I don't know if the arrest affidavit goes into detail about how they knew the gun was stolen. They didn't describe the type of firearm. Sometimes they'll go into the serial number of the weapon. So I would have you consider that as far as probable cause on count 17.
What says the state?
Your Honor, the affidavit doesn't go into specifics regarding the stolen firearm, such as a serial number. Just states that the stolen firearm was located in the floorboard of where Mr. Brennan was observed sitting. So state has no objection to ROR as to count 17.
All right, I'm not sure I agree with your argument, Mr. Brantz, because the affidavit does allege that it's a stolen firearm. However, based on the state, I will ROR him on that count. I think there's still probable cause, but I'll still ROR him on that count. So count 1, his bond will be $200,000.
Your Honor, state also has no objection to treating each individual ammunition as a subsidiary. Given that the officer charged all 14 bullets.
All right, so 2 through, is it 15, 14? Will be $150 bond. Which one of, tell me the number of the possession of firearm by convicted felon. Count. Okay, so 16 will be $4,000, ROR on 17. 18 is $3,000 and 19 is $100. No weapons, firearms, or ammunition. No contact with any victim or witness in the case. Is that another bullet? Yes, sorry. There were so many, I did the math wrong. 100, yes, thank you.
Your Honor.
Yes.
Mr. Roger Webb bonded. Did you have that?
Okay, so Roger Webb bonded.
Right.
Sir, please tell me your name.
Gerald Wayne Gerson.
All right, sir, you're here in 21 CF 14611, charged with 3 counts of possessing material that depicts a sexual performance by a child. At this time, I'll appoint an attorney to represent you. Give me one moment.
Yes. I'm sorry.
Just give me one moment, sir. I have to pull something up in the computer and it's just moving really quickly. I mean, moving really slowly. There is probable cause. Does the state wish to be heard on bond?
Yes, Your Honor. Given the nature of the accounts, they are all F3s involving children, and one of them allegedly was a child that he had contact with. So given that, and given that it looks like he has a warrant out of Virginia, also for a sex assault case. He potentially has limited criminal ties to the area, and given that they are child sex offenses, Stacia's asking that you said we have a bond on all 3 counts.
Did you say no bond?
No, Your Honor, he's entitled to bond. They're all F3s. Just would like you to take into account that warrant out of Virginia. That's also a sex assault case.
I see that. All right, Mr. Brantz, anything from the defense?
Just a reasonable bond, as he is entitled to it, Your Honor.
Sir, your bond will be $50,000 on each count. With special conditions, you can have no contact with any minor child under the age of 18. Do you understand what no contact means? You can have no contact with any victim or witness in this case. Any other conditions the state would request?
State would ask for no return, Your Honor. One of the victims in one of the videos allegedly resided with the defendant.
Oh. Resided with him?
Yes, Your Honor. It's alleged within the affidavit that the 6-year-old female resided with the defendant from the previous arrest on October 12th for the sex violent child under 12.
Oh, I see.
And that child was depicted in one of the videos from this case.
All right, you're not allowed to return. Do you have the address, counselor?
It's 1306 Cardinal Lane.
You can't go back there for any reason. Do you understand? All right, good luck, sir. Please stand. Oh,
Oh, he don't need, he doesn't need Spanish, Your Honor.
he doesn't? Please tell me your name. 2014 MM 2024. Sir, you're here because a capias was issued for your arrest for failing to appear for arraignment on a charge of petty theft. The bond authorized is $350.
Your Honor, state did convey an offer if the defendant wanted to resolve this case of an adjudication credit time served and no return to 7825 South Orange Blossom Trail.
Your Honor, I did have a chance to speak with Mr. Colon about the state's offer. I conveyed a plea form for him to review. We spoke about the effects of entering a plea, and I believe Mr. Colon wishes to resolve the case today.
Sir, please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
You had a chance to speak with an attorney before court about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, Honor.
You can keep your hand down. Thank you. Mr. Brantz, did you discuss with him petty theft is an enhanceable offense?
Yes, Your Honor, as well as the issue with probation and citizenship, and he still wished to enter a plea of no contest today.
All right, sir. So you understand that petty theft is what we call enhanceable, which means after a certain number of convictions, the state can file that as a felony. You understand that? Understanding that, do you still wish to enter a plea of guilty or no contest today?
Yes.
All right, you understand that if you're on probation anywhere, this plea could violate that.
Yes, ma'am.
Is he on probation?
No.
No, he's a current DOC inmate.
All right, so he's going back to DOC?
No, his release date is
I released yesterday.
Okay. You understand if you're not a U.S. citizen, you can be deported?
Yes.
All right, at this time, how do you wish to plead to the charge of petty theft?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for 2 days in custody. I have to order that you pay court costs. I'll give you a year to pay those, and you cannot return to the address that the prosecutor put on the record. Do you understand?
Yes.
Good luck, sir. You have 30 days to appeal in writing.
I released today, right?
As long as you don't have any other holds, you will be.
I don't got any hold.
So, yes.
Were we appointed in that case, Madam Clerk? No? Okay.
Thank you so much for this day. Thank you.
Yes, sir. Have a nice day.
I spoke to Mr. Colon as a friend of the court, yeah.
I'm sorry? Yes. Yes. I didn't appoint you. You probably won't have to deal with that. So I won't. That's why.
Good morning. This is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good morning. This is Judge Gibson. If you could please connect with a headset.
Yes, Your Honor.
Sí, sí, escucho.
He can hear the interpreter, Your Honor.
Thank you. Please tell me your name.
Luis Alfonso Lenis.
Luis Alfonso Lenis.
Sir, you're here in 21 CT 7482 and 7485, charged with driving while under the influence and refusal to submit to a DUI test. There is probable cause. I'll appoint an attorney to represent you in each case. Your bond on the DUI is $500. On the refusal is $500. With special conditions, you can't possess or consume any controlled substance without a valid prescription or any alcoholic beverages. You'll be subject to random drug and alcohol screens, and you can't drive without a valid Florida license. Good luck, sir.
Your Honor, what was the defendant's last name, please?
Lenis.
Thank you.
Was RUA on both of the cases?
I'm sorry? Yes. Sir, please tell me your name.
Luis Zapata. Zapata.
Luis Zapata.
You're here because a capias was issued for your arrest in 2010 CT 5030 for failing to appear for a DUI. The bond authorized is $2,500. I'll appoint an attorney to represent you. Good luck, sir. Right. Is that it for Spanish?
Yes, Your Honor.
That's all we have for the interpreter.
Thank you, Your Honor. Have a great day.
Please tell me your name.
Ramonte Birch.
21 MM 7990. You're here charged with battery. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can have no contact with any victim or witness. You can't return to the scene, and you can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
All right, good luck, sir. All right, that's 21 MM 7993. Mr. Brantz, I'm going to appoint your office in that case.
What was the reason again? I'm sorry.
It's mental health.
I will waive the appearance, Your Honor.
There is probable cause. His bond is $500 with a no return, no contact with any victim or witness. I'll take no action on the out on bond cases.
Thank you, Your Honor.
You will, it's right there.
And I'm sure that's you.
I'll tell you. Well, maybe not. Please tell me your name.
Hi, Evan Howe. Good morning.
Good morning. You're here in 21 MM 7994, charged with disorderly conduct and resisting an officer without violence. Was there an offer in this case?
Yes, Your Honor. And the victim, arguably, of the disorderly conduct is also in custody unless he's otherwise bonded. I don't know if you want him in here as well. But there was an offer conveyed of a withhold, credit time served, and no contact with that co-defendant / victim, and no return. Otherwise, he would likely qualify for PTD downtown.
I Your Honor, I did speak with Mr. Ho about speaking with one of our attorneys, and he wanted to do that. So I would request ROR on these charges, as well as bring up Mr. Eric Nam to testify to contact, so that I believe they are acquaintances.
It's not a battery. It's a disorderly conduct.
Yes, Your Honor. The underlying basis of it was a battery between the two of them.
But if in your discussion you don't need to order no contact, then we don't need to bring them both up, I don't think.
Yeah, I'm just going to order no contact. I don't need them here at the same time.
Well, I guess my argument was because they know each other, if they could have peaceful contact with each other.
All right, can you bring him in here?
Non-bonded.
Oh, he's gone? All right, sir. I'll appoint an attorney to represent you. Your bond on count 1 is $100. Your bond on count 2 is $500. With special conditions, you can't return to the Vanguard Theater. Do you understand?
Understand.
You can't possess a weapon, firearm, or ammunition.
I don't.
I'm going to order that you can't have any contact with Eric Nam at this time. All right, good luck, sir. Victim. I mean...
Co-defendant.
Co-defendant, yeah. It's not a victim, because it's not a battery. Please tell me your name.
Robert Lloyd.
21 MM 7986. You're here charged with criminal mischief. I'm going to appoint an attorney to represent you in this case. There is probable cause. Give me one moment. I'll stay your bond at $1,000 with special conditions. You can't return to the scene and you can't have contact with any victim or witness in the case. Do you understand?
Yes.
All right, good luck. (21 MM 7979). I'll find his refusal a willing waiver of his appearance today.
There was no offer, Your Honor, due to being enhanceable.
Thank you. Thanks. All right. Mr. Brands, I'll appoint your office. There is probable cause. Bond is $500, no return, no contact with any victim or witness. Were there any other conditions the state would request?
No, Your Honor.
Please tell me your name.
DeMonte Seawright.
Good morning. You're here in 21 MM 7984, charged with resisting an officer without violence. Was there an offer in this case?
Not at this time, Your Honor.
Oh, no.
There is probable cause. I'll appoint an attorney to represent you. Your bond is $500.
Yeah.
You can't possess a weapon of any kind, firearm, or ammunition. Good luck, sir.
Okay.
Please tell me your name.
Elizabeth Torres.
You're here in 21 MM 7982, charged with retail petty theft. Was there an offer in this case?
No, Your Honor, due to being enhanceable.
All right, ma'am, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500. You can't have contact with any victim or witness, and you can't return to the Dollar General at 50 South Rosalind Avenue. Good luck. Please tell me your name.
Walter Wright.
You're here in 21 MM 7991, charged with resisting an officer without violence. Was there an offer in this case?
No, Your Honor, due to there being an uncharged petty theft.
All right. At this time, sir, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500. You can't return to, do you have the address, counselor?
Yes, Your Honor.
Walgreens.
Walgreens at 4720 South Kirkman Road.
And you can't possess a weapon of any kind, firearm or ammunition, or have contact with any victim or witness in the case. Good luck, sir. Okay. What about? All right. Please tell me your name.
Stephen Bishop.
21 CF 14628. You're here charged with aggravated assault with a deadly weapon. At this time, I'm going to appoint an attorney to represent you. There is probable cause here. Give me one moment. I'll stay your bond at $5,000. With special conditions, you can have no contact with any victim or witness in the case. You can't return to this scene for any reason. You can't possess a weapon of any kind, a firearm or ammunition. Do you understand?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
William Blaze, Jr.
You're here in 21 CF 14603, charged with possession of methamphetamine. There is probable cause. I'll appoint an attorney to represent you. Mr. Brantz, did you wish to be heard on bond?
Your Honor, I think based on our discussions on Wednesday, and as he otherwise does qualify for PTR, perhaps a lower bond than the standard one of 1,000, maybe a 500 or 250 bond.
And not pretrial release?
Your Honor, state would just ask for straight pretrial release.
Actually, Your Honor, he wouldn't qualify doing further research on this defendant. He's currently on probation.
Oh, he's currently on probation?
Is it out of Orange?
You have a moment to confer, Your Honor.
Yes.
Thank you, Your Honor.
All right, at this time, sir, your bond is $1,000 with special conditions. You can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. And if you are currently on probation, a violation of probation warrant might follow. So I just want you to be aware of that. So I would call my attorney right away if I were you. On the number on that green piece of paper. Sir, you can say anything you want. Everything you say is being recorded and can be used against you later.
Okay, well, just recently.
Has a warrant been served on the violation of probation as of right now?
It has.
It has? Okay.
Oh, it has?
It has.
Oh.
You'll be seeing on it tomorrow.
Okay. Oh, not you. You this weekend? Okay. Good luck, sir.
Thank you.
Yeah. Please tell me your name.
Courtney Bozeman. Yeah.
I'm sorry, did you say Bozeman? Yes. All right, you have 3 cases, ma'am. 21 CF 6190. A warrant was issued for your arrest, charging you with neglect of a child.
And information has subsequently been filed, Your Honor.
Is that the charge?
Yes, Your Honor.
All right, does the state wish to be heard on bond?
Yes, Your Honor. Given the nature of the offense that a child was involved, also given that she did have a prior failure to appear recently at the end of 2019, as well as has a pretty extensive out-of-state history, state is concerned about her connections within the community and securing her to come back. In addition to that concern, she failed to appear on the child neglect case, and then when she was trying to be arrested is when we picked up the resisting without, also showing state's concern of her willingness to come back to court and deal with these charges.
Anything from the defense, Mr. Brantz?
He is entitled to a reasonable bond on these charges, Your Honor. Just a moment to confirm.
Your Honor, I believe the failure to appear is potentially the original capias. You see that within your system?
Just one moment. Let me pull that one up.
I believe that was the original warrant.
It's for failing to appear for a status hearing on a charge of neglect of a child. It shouldn't be, because there wouldn't be a status hearing unless it had been charged, so that's a different case.
Okay.
So the information filed.
The 5691 neglect case?
5691 is that case.
Okay, never mind.
All right, so let's go back to the 6190, the warrant. Mr. Brantz, did you wish to be heard?
He is entitled to a reasonable bond on these charges, Your Honor, but nothing further.
All right, ma'am, your bond is $10,000. You can have no contact with any minor child under the age of 18. Do you understand?
Yes.
All right, you must comply with any plan set in place by DCF. Any other conditions the state would request in that case?
Your Honor, state would ask for no weapons, firearms, or ammunition.
You can't possess any weapons, firearms, or ammunition. And you can't possess or consume any controlled substance without a valid prescription. In 21 MM 7981, there is probable cause for the charge resisting an officer without violence. I'll appoint an attorney to represent you in that case as well. Your bond is $500. Again, you cannot possess a weapon of any kind. In 21 CF 5691, a capias was issued for your arrest for failing to appear for a status hearing on a charge of neglect of a child. The bond authorized is $1,000, and I'll appoint an attorney to represent you in that case as well. Good luck, ma'am.
Someone needs to call the case room.
Yes, ma'am. Good morning. Please tell me your name.
Davidson, sorry.
You're here in 2020 CF 13534 because a capias was issued for your arrest for failing to appear for a hearing on charges of battery on a law enforcement officer, resisting without violence, possession of a controlled substance, drug paraphernalia, and resisting an officer without violence. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. At this time, I'll take no action on the out on bond.
I was in Pinellas County Jail on a charge that later got dropped. There was also a plea date that was set. So I've already been in contact with my public defender, and we still have the same plea. Now, if we could schedule a plea date for preferably this month.
So I'm glad that you've already contacted your attorney because it sounds like you think you have a defense to the failure to appear charge, but because it's a capias, I can't change it. So your attorney is going to have to make that argument in front of the trial judge. Good luck, sir. Yes, sir.
Your Honor, Douglas Antoinette bonded.
Thank you. Please tell me your name.
LaShawn Falk.
19 CF 6427. You're here because a capias was issued for your arrest for failing to appear for trial case management on charges of grand theft and resisting without violence. There is no bond authorized on that capias, and I'll appoint an attorney to represent you. Good luck. Please tell me your name. Sir, you can't tell me your name? I don't understand.
Can someone please look at his ID?
Mr. Fortune, do you need an interpreter?
Your Honor, may I approach on this? May counsel
Yes.
approach?
They have.
All right, Mr. Fortune, you're here in 21 CF 14618, charged with battery on a law enforcement officer. I reviewed the affidavit. There is probable cause for that charge. I'm appointing an attorney to represent you, and he's going to look for something really quickly for me.
Yes, just a moment, Your Honor.
Your Honor, I see on 11-4, the court minutes, defense counsel withdrawal suggestion of incompetency based on evaluation results.
Withdrew it? All right.
On our system, I had a notice of incompetence, so I assume that was.
There was a motion on 9/23. I believe there was a comp eval that occurred, and then at the 11-4 status hearing, Per the court, defense counsel withdraw suggestion of incompetency based on evaluation results.
I see that as well, Your Honor.
All right, so anything else on that, Mr. Brandt?
Nothing further, Your Honor.
All right, in this case, sir, your bond is $5,000. You can not possess a weapon of any kind, firearm or ammunition.
Would you consider a revoke and double on the out on bond case, Your Honor?
No, I'm going to revoke that. Your office is going to have to file a motion in front of the trial judge. Good luck, sir.
Your Honor, Freeman Brianna, mental health.
Thank you. 21 CF 14615. Mr. Brandt, I'll appoint your office in that case.
Waive the appearance, Your Honor.
Your Honor, I don't believe this case should be charged as a principal of criminal mischief, as she is the sole person. I'm double checking to make sure the statute is the same. The state would ask that you find PC for criminal mischief over 1,000.
There is probable cause. What would be the principal theory in this case?
I'm not sure, Your Honor. I believe it was just a scrivener's error potentially from the law enforcement officer.
Okay.
Correct statute. Correct statute's 806-131B3. So it is correct. I don't know why the principal's in there.
All right.
They would just ask that you.
There is probable cause for criminal mischief, damage greater than $1,000. Yes. I'll stay the bond at $2,000 on count 1, $500 on count 2. Cannot return to the scene for any reason. No contact with any victim or witness in the case. Cannot possess a weapon, a firearm, or ammunition.
Anthony Khalik, Singh, surety bond.
Okay.
Jonathan La Rosa, medical.
21 CF 13678. I'll appoint your office, Mr. Brandt.
We'll waive the appearance, Your Honor.
It's a warrant, so probable cause is already found. I'll stay the bond at $1,000. No contact with any victim or witness, not return to the scene. Are there any other conditions? All right.
You're,
Yeah.
Your Honor. Your Honor.
Yes.
Is there a status update on the language line? Because I know they go to lunch at noon.
No, that's the interpreters,
Oh,
not the
so-
language line.
Oh, okay. All right. Never mind.
But thank you for watching the time. That is between so any day. Okay. Please tell me your name.
Amari Lopez.
21 CF 13265. You're here charged with burglary of a structure with assault or battery. A warrant was issued for your arrest, so another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard?
Yes, Your Honor. Given that she's charged with the F1 that's punishable by life, state's asking that you hold her no bond pending an Arthur hearing downtown.
What says the defense?
No argument, Your Honor. She is entitled to that hearing with her attorney.
All right, ma'am, at this time you'll have no bond. However, even while in custody, you can have no contact with the victim or any witness in this case. Do you understand?
Yes, Your Honor.
All right, good luck. Wait, hold on, there's other conditions on the warrant. But yeah, because she's in custody, she can't do any of those things. I mean, I guess I can just leave them. It's okay, just leave them. I'll leave the other conditions that are in the warrant, not return to the scene, no weapons, firearms, or ammunition, but she can't do those things anyway in custody.
Understood. Thank you, Your Honor.
Your Honor, Lozada Flores Cristobal is medical.
21 CF 14627, Mr. Brantz, I'll appoint your office.
We'll waive the appearance, Your Honor.
There is probable cause.
Actually, I'm sorry, Your Honor, may we go back to count one?
Instruction of evidence.
Yes, I didn't see any facts in the affidavit that they didn't recover or did recover any of the evidence that Mr. Flores was attempting to put into his mouth, so I would have you find probable cause for attempt of destruction of evidence.
State has no objection, Your Honor. I believe Orange County Fire arrived on scene due to the possibility that he swallowed it. We don't have any actual evidence that anything was swallowed. The officer just saw him place multiple baggies within his mouth. So state would have you find PC for the attempted destruction, which would be the same statute, and then the additional 77704.
All right, I'll do that. Did you get that? Bottom part? It's the same statute plus attempt, which is
7.04.
Yes, but I'll stay the bond at 1,000 on count 1 and 2, 500 on 3 and 4. Cannot possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Any other conditions the state would request?
No, Your Honor.
All right.
Your Honor, what's the status of case with Janier Tito Lopez?
Jamari?
No, it was
Give me the case number.
21 CF 8414. Oh, was that the private counsel?
Yes.
Oh, I'm sorry. Okay, I'm sorry. That was from this one.
Martino Demotrick, surety bonded.
All right. Please tell me your name.
Jason McLean.
Mr. McLean, you're here in 21 CF 6445 CO. A capias was issued for your arrest. Give me 1 moment.
Yes, Your Honor. There was since an indictment on.
Oh, an indictment?
26, yes.
All right. Is it the same charges?
Well, originally we filed on 3 charges, and then we withdrew that, and then there was an indictment from 826 with that first-degree murder with a weapon and the home invasion robbery with a weapon.
Okay, I have first-degree murder with a firearm and home invasion with a firearm.
Yes, Your Honor.
All right, that is what was charged in the indictment?
Yes, Your Honor.
All right. Mr. McLean, I'm going to appoint an attorney to represent you in this case. Because the indictment has been filed, is there a third count?
There was, Your Honor. That was not
All right.
charged.
Does the state wish to be heard on bond?
Yes, Your Honor. Given that count 1 is a capital offense and given that count 2 is an F1 that it's punishable by life, state's asking that you hold him no bond on both until he has an Arthur hearing downtown with his attorneys.
Any response, Mr. Brantz?
No argument pending that Arthur hearing.
All right, sir, because these are punishable by life offenses at this time, you'll be held at no bond. However, even while in custody, you can have no contact with any victim family members.
Excuse me?
While you're in custody, you can't have contact with any family members of any victims in the case. Do you understand?
My family members? Oh, all right. Yes, ma'am.
Okay.
Right. Family members of the victim.
Of the victim. Yes.
Your Honor, state would also ask for no contact with the co-defendants as he is the third.
You're correct. Can you bring him back? I did not. I'm sorry, sir. First, I misspoke. Count 1 is a capital offense. Count 2 is punishable by life. Also, even while in custody, you can have no contact with any co-defendant in this case. Do you understand?
Yes, ma'am.
All right. Good luck, sir. Good. Please tell me your name.
Perquan McIntosh.
21 CF 14626. You're here charged with possession of cocaine with intent to sell or deliver with a firearm, carrying a concealed firearm, and resisting without violence. I'm going to appoint an attorney to represent you. There is probable cause here. Did the state wish to be heard on bond?
Your Honor, it seems like he has a very limited criminal history. So state would just ask for a reasonable bond as all counts.
All right, Mr. Brantz, anything from the defense?
No argument. Just he's entitled to a reasonable bond on all counts, Your Honor.
Sir, your bond is $15,000 on count 1, $4,000 on count 2, $100 on count 3. With special conditions, you can have no contact with any known drug dealers. You can't possess a weapon of any kind, firearm, or ammunition. You can't possess or consume any controlled substance without a valid prescription. Do you understand? Good luck, sir. Please tell me your name.
Norman Moore.
In 21 CF 14567, a warrant was issued for your arrest, charging you with failure as a sexual predator to report and re-register. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Just the warrant. Does the state wish to be heard on bond?
Your state would just have you take into account that he is currently also out on bond for another failure to register case. And I believe got out of DOC for also a failure to register back in 2014. So it seems to be an ongoing issue. So they would have you take that into account when setting his bond on this charge.
All right, sir. Your bond on this charge will be $25,000 with special conditions. You must comply with all reporting requirements. Any other conditions the state would request?
No, Your Honor.
In 21 MM 762, you're here charged with resisting an officer without violence. There is probable cause. I'll appoint an attorney to represent you in that case as well. Your bond in that case will be $500. And at this time, I'm revoking your out on bond cases. Good luck, sir. Please tell me your name.
Zemunet Ramos.
You're here in 21 CF 14588. A warrant was issued for your arrest, charging you with battery with 2 prior offenses. Another judge has already found probable cause in this case. Your bond is $5,000. You can have no contact with any victim or witness in the case. You can't possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request in this case?
No, Your Honor.
And sir, while you're out, you must comply with any sex offender reporting requirements. Good luck. I show that he's a violent felony offender of special concern and on state probation, so he has some holds.
Yes, Your Honor.
All right, good luck, sir. Please tell me your name.
Mark William Nichols.
21 CF 14614. You're here charged with possession of fentanyl, possession of a controlled substance with intent to sell, possession of cannabis under 20 grams, possession of methamphetamine, possession of drug paraphernalia, and possession of Xanax.
Yeah.
At this time, I'll appoint an attorney to represent you.
Your Honor, as to PC on count 6, I don't know if there were any facts in the arrest affidavit that indicated Xanax was found. It was just charged. As like one of the last lines in the affidavit, but I combed through the materials found on Mr. Nichols, and I don't believe there was any Xanax, or at least there wasn't any written in the affidavit.
What says the state?
1 second, Your Honor. Your Honor, I believe defense counsel is correct. However, state's not going to ask for 24 hours just for count 6. So they would just ask that you RORs to count 6 and set reasonable bonds as to 1 through 5.
I see that he has 6 prior failures to appear. His last conviction was for a violation of probation in 2019. He has a very extensive drug history. At this time, sir, your bond on count 1 is $2,500, count 2 is $5,000, count 3 is $100, count 4 is $150, count 5 is $100. I'll ROR you. I'll release you on your own recognizance as to count 6. With special conditions, you can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers.
Yeah.
Good luck, sir.
Good morning, Your Honor.
Good morning. Please tell me your name.
I come in special appearance questioning the defendant for Richard Ortiz.
Thank you, Mr. Ortiz. You're here in 21 CF 14632, charged with carrying a concealed weapon by a convicted delinquent, resisting an officer without violence, possession of a firearm in the commission of a felony, grand theft of a motor vehicle, possession of a firearm by a convicted delinquent, 2 counts, possession of ammunition by a convicted delinquent. Is that all the charges in this one? Yes. At this time, sir, I'm going to appoint an attorney to represent you. Mr. Brantz, did you?
I object, Your Honor.
I understand. And listen, what we're here for today is probable cause and bond. You can object. What I'm going to do, though, is appoint the public defender's office to represent you just for purposes of right now, and I'll tell you why.
Your Honor, I object.
I understand. Let me tell you why. Right now, because of the global pandemic, the Florida Supreme Court has said that everyone should be appointed a public defender, at least provisionally. It doesn't mean you have to keep the services of the public defender's office. At any time during your case, you can tell your judge that you don't want them representing you, and they can be removed from your case. Okay, so I'm just doing it right now because of that Supreme Court order.
Do I have a choice?
You have a choice, but I'm bound by that order. So for today, I'm going to appoint them provisionally.
I object.
I understand. Now let me ask, Mr. Brantz, since provisionally you're going to represent him,
Yes, sir.
did you wish to be heard as to any of these counts?
Not at this time, Your Honor.
I agree, but I wanted to give you the opportunity.
Thank you, Your Honor.
Does either side wish to be heard on bond?
I ask for a $2,000 bond, Your Honor.
All right, thank you, Mr. Ortiz.
Your Honor, state, he has a lot going on between out-of-county warrants from Seminole, I believe in 2 different out-of-county warrants, as well as 3 out-on-bond cases. So state, we just ask that you said reasonable bond, that's all counts. I don't have an updated one with his criminal history. However, I can pull it, and I don't know how many prior failures to appear he has, so I can't speak to that at this moment.
All right, thank you. At this time, Mr. Ortiz, your bond on count 1 is $4,000.
Your Honor, I asked for...
I heard you, Mr. Ortiz, but I don't think that's reasonable given your history and...
Don't I have the constitutional rights for a $2,000 bond if I ask for it, Your Honor?
You do not.
I do not?
You do not.
All right.
You have a constitutional right to a reasonable bond. There are many things that the judge has to consider with setting bond, such as your history, such as the facts in this case. One of the purposes of bond is to secure your presence for future court dates. So the court has to consider all of those things when setting bond.
Yes, Your Honor.
You are, however, entitled to a reasonable bond. You're correct about that. I'll set count 2 at $100.
Thank you, Your Honor.
Yes, sir. Count 3 will be $5,000. Count 4 will be $3,500. Count 5 and 6, I'll treat as subsidiaries and set them at $150 each, as well as count 7. No. Yes, count 7. With special conditions, Mr. Ortiz, you cannot possess a weapon of any kind, firearm, or ammunition. You can't have contact with any co-defendant in this case. You can't return to the Quality Inn and Suites located at 2601 McCoy Road. Are there any other conditions the state would request?
No, Your Honor.
Sir, do you live in the Bay Hill area?
I live in a house.
I'll tell you why I'm asking. I'm going to order that you can't return to Bay Hill. Does that mean that you can't go home?
Sorry, can you please...
Do you know where Bay Hill is?
No, ma'am. I might. Is it a road?
Bay Hill, isn't it near Dr. Phillips area? I don't want to make him not able to go home.
I stay around Whisper Lakes, John Young, Orange Blossom. It's 11602 Purple Lilac Circle. It's Whisper Lakes.
Okay, that's not near Bay Hill.
Yeah.
All right, so don't go back to the Bay Hill area.
I got you, ma'am.
That's out by Dr. Phillips. So when you get out, look up where that is and don't go back there.
Yes, ma'am.
I don't want you to get in trouble for being where you're not supposed to be.
Thank you.
Okay. All right. Good luck, sir.
Your Honor, he also has the 2 warrants and the...
Oh, that's right. I'm sorry. You have 2 warrants. In 21 CF 2123, looks like you have a warrant out of Seminole County for failing to appear for arraignment. At this time, there's no bond on that, and I can't change it. We'll notify them that you're here, but you're going to have to address that in Seminole County because I don't have jurisdiction over that.
Yes, Your Honor.
And then in 21 MM 2585, you have a warrant for...
New Jersey,
one moment.
Atlantic City.
It's what?
New Jersey, Atlantic City.
I don't... Hold on. Let me pull it up. It's what?
Seminole County.
It's still Seminole County? No, that's also out of Seminole County.
Mm.
The bond on that is $2,000. Again, I can't change that. You have to address it in Seminole County. What about these out-on-bond cases?
Your Honor, this time state's asking that you revoke them due to the nature of those offenses are very similar to the ones that he recently picked up, and they're all violent in nature.
Were those out of Bay Hill? I'm not asking you, you don't have to say anything.
The 2300.
While she's looking for that, we have the Creole interpreter on the line. Okay, good.
I believe they're out of Osceola, Your Honor.
Okay. All right. I'm going to revoke your bonds in those cases at this time.
Thank you, Your Honor.
So, Mr. Ortiz, I know that you don't want to be represented by the Public Defender's Office, but since you are for right now, I would just encourage you, call the phone number on that green piece of paper and talk to your attorney right away. Again, you can ask the judge to remove them at any time later in your case, but you have a lot going on here, and I want to make sure that you at least get the benefit of that representation while you have them.
Thank you, Your Honor.
Yes, sir. Good luck.
You have a beautiful day.
You as well. Thank you. This is Judge Gibson. Who do I have on the line?
This is Anne, interpreter ID number 200857 for Haitian Creole.
Madam Interpreter, it's really difficult for us to hear you. You're very soft, and I have the volume turned up in the courtroom. If you could please get as close as you can to your phone or microphone.
Yes, Your Honor. It's pretty close. Hold on 1 second, please. Make sure.
Thank you.
Is it any better for you now?
That is much better.
Okay, keep going.
Has the interpreter been sworn?
Not yet.
Please raise your right hand to be sworn.
Do you solemnly swear to translate from Creole to English, from English to Creole to the best of your ability?
I do.
Thank you.
Sir, please tell me your name.
Monsieur, s'il vous plaît, dis-moi tout nom. Comment?
Non, famille, c'est Jean, prénom c'est Robert.
Robert Jean.
Oui.
Sir, you're here in 19 CF 12110 because a capias was issued for your arrest.
Your Honor, could you repeat that again?
Sir, you're here because a capias was issued for your arrest.
Monsieur, ou là, parce que yo te voye yon KPS pour arrestation.
For failing to appear for a hearing on a charge of battery on a law enforcement officer.
Parce que ou pas présenter tête ou yo te accusé ou que ou te frappé yon officier, un chef, mon pas présenter tête ou là te supposé venir.
At this time, there is no bond authorized on that capias.
Pour qu'on y ait, yo pas autorisé aucune liberté conditionnelle, aucun bon.
I'll appoint an attorney to represent you.
Ma mette yon avocat sous ka la pour ka défendre.
Oui.
Yes.
All right, good luck, sir.
Bonne chance, monsieur.
I believe that's all we have for the Creole Interpreter.
Thank you, Your Honor. Thank you for using our services.
Have a nice day.
Thank you, ma'am. You too.
Please tell me your name. Oh.
Ramiles Pierre.
21 CF 14639. You're here charged with sexual battery with a firearm and aggravated assault with a firearm. At this time, I'm going to appoint an attorney to represent you. Mr. Brandt, did you wish to be heard on either of these charges?
Not at this time, Your Honor.
All right, sir. There is probable cause for these charges. Does the state wish to be heard?
Yes, Your Honor. Given that count 1 is a first-degree felony that's punishable by life, state's asking that you hold him no bond pending an Arthur hearing.
Anything from the defense, Mr. Brandt?
No argument on that either, but he is entitled to a hearing with his attorney.
He is. Sir, at this time on count 1, you'll have no bond. On count 2, your bond will be $25,000 with special conditions. Even while you're in custody, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
I do.
On count 2, you can't possess a weapon of any kind, firearm, or ammunition. You can't return to the scene for any reason. You can't be within 1,000 feet of the victim's residence or place of employment. Are there any other conditions the state would request?
No, Your Honor.
All right. Please tell me your name. Sir, you're here because a warrant was issued for your arrest in 21 CF 14638. The warrant charges you with first-degree murder. At this time, I'll appoint an attorney to represent you. Does the state wish to be heard?
Yes, Your Honor. Given that he's charged with a capital offense, state's asking that you hold him no bond pending an Arthur hearing.
Mr. Brantz, any response?
No argument, Your Honor, pending that Arthur hearing.
All right, sir. Because it's a warrant, another judge has already found probable cause in this case. I will hold you at no bond. However, even while in custody, you can have no contact with any witness, co-defendant, or any family member of the victim. Do you understand that? All right.
Your Honor, do you mind repeating the case number you have on that?
I'm sorry, the what?
The case number you have?
14638.
Thank you.
Please tell me your name.
Evan Prinville.
21 CF 14631. You're here charged with possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, and possession of cannabis less than 20 grams. I'm going to appoint an attorney to represent you in this case. There is probable cause. I'll stay your bond at $4,000 on count 1, $1,000 on count 2, $100 on count 3 with special conditions. You can't possess or consume any controlled substance without a valid prescription. You can't possess a weapon of any kind, firearm or ammunition, and you can't have contact with any known drug dealers. Good luck, sir.
Your Honor, Service Leo Shirley Bond.
Thank you. Please tell me your name.
William Shaw.
21 CF 14630. You're here charged with aggravated assault with a deadly weapon. I'm going to appoint an attorney to represent you in this case. There is probable cause. Your bond is $5,000. You can have no contact with any victim or witness in this case. Ms. May, do you know if this injunction is on the same victim? Is with the same victim?
I can double check. 1 second, Your Honor. Your Honor, I don't see that injunction out of Orange. I don't know if pretrial has any other information.
Okay. All right, I'll stay the bond at $5,000. You can't have contact with any victim or witness in this case. You can't return to Rocco's Tacos for any reason. You can't possess a weapon of any kind, firearm or ammunition. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Oh, we have the Vietnamese interpreter. This is Judge Gibson. Who do I have on the line? Oh. This is Judge Gibson. Who do I have on the line?
Hello, my name is Nee. I'm the Vietnamese interpreter.
Has the interpreter been sworn?
No.
Please raise your right hand to be sworn.
Do you solemnly
Yes,
swear
Honor.
to translate from Vietnamese to English, from English to Vietnamese to the best of your ability?
Yes, I do swear.
Thank you.
Good morning, sir. Please tell me your name.
Chào ông, làm ơn cho tôi biết tên của ông.
Ông Nguyễn Ngọc Tuấn.
Nguyễn Ngọc Tuấn.
He said his last name first. Win Ton.
I see. Sir, you're here in 21 CF 14619, charged with possession of ammunition by a convicted felon.
Dạ, số hồ sơ của ông. This city interpreter, can you please repeat the first number?
21 CF 14619.
Số hồ sơ của ông 21 CF 14619.
Okay.
Okay.
At this time, I'll appoint an attorney to represent you.
Vào thời điểm này, tôi sẽ chỉ thị một luật sư đại diện cho ông.
There is probable cause.
Có thể sẽ có khả năng phải trả chi phí.
Your bond is $4,000.
Số tiền thế chân tại ngoại của ông là 4.000 đồng.
Your Honor, as to that bond amount,
I'm sorry, I could not hear that voice. It sounded very far away.
Your Honor, can I be heard on the bond amount?
Vâng, thưa quan tòa, tôi có thể được biết về số tiền tại ngoại hay không?
Yes.
Được.
The arrest affidavit said that Mr. Nguyen found one bullet and had it in his pillowcase.
Đương đơn báo cho biết rằng phát hiện được một bullet nằm trong cái gối, nằm trong cái bao gối.
I would just have you consider that in your bond determination, Your Honor.
Và tôi nghĩ rằng quan tòa nên cân nhắc về vấn đề này khi nhắc tới số tiền tại ngoại.
Any response from the state?
Có bất kỳ lời đáp hồi gì từ tiểu bang hay không?
Ông nói bảo cái viên đạn đó là
Excuse me, Honor, I need to have him repeat. I couldn't hear him.
All right, ask him to repeat it.
Chú nói lại ạ.
Nói với bạn cái viên đạn đó là không phải của chú không, tại chú lụm được ở cái bãi đậu xe ở chỗ downtown Orlando, rồi chú đâu biết là đâu biết giữ đâu.
Sir, I'll ask that you speak in short sentences for the interpreter.
Chú chỉ cần nói những câu ngắn gọn để cho người thông dịch ạ. The bullet is not mine. I got it in downtown Orlando, and I kept it, but it was not mine.
I understand.
Tôi hiểu được vấn đề này.
Sir, the reason you're here today is for me to determine probable cause and bond conditions.
Thưa ông, lý do về việc ông có mặt hôm nay là để cho tôi đưa ra cái quyết định về các số tiền tại ngoại, về số tiền thế chân tại ngoại của ông.
Any defenses you have to this charge, you'll have to raise later through your attorney.
Bất kỳ những cái lời biện hộ gì của ông có thể giữ lại để nói về vấn đề sau này khi ông nói chuyện với luật sư của mình.
Yes, ma'am.
He said yes.
All right.
Your Honor, in brief response,
Oh, yes, please proceed, Ms. May.
this allegedly occurred outside the FDLE building, which is slightly concerning.
Chúng tôi lo ngại về vấn đề này vì vấn đề này xảy ra xung quanh tòa nhà.
In addition to possessing the round of ammunition, he was also allegedly in possession of paraphernalia.
Và đồng thời chúng ta phải cân nhắc về vấn đề lý do an toàn.
He also has been convicted of a felony and therefore is a convicted felon from multiple cases in multiple states.
Và ông ấy bị buộc tội về tội hình sự. Tội hình sự có thể ảnh hưởng tới các nguyên tố khác và có những cái điều lệ riêng của nhiều tiểu bang.
The purpose of bond is to secure him coming back to court to deal with these charges. State has current concerns over the failure to appear, as well as his out-of-state history regarding potential inadmissibility.
Và chúng tôi nghĩ quan tòa nên cân nhắc lại số tiền tại ngoại này vì lý do về các vấn đề đã xảy ra và đồng thời đương đơn có tiểu sử khi không chấp thuận với các điều khoản đã được lập ra ở các tiểu bang khác.
Thank you. Any response, Mr. Brandt?
Ông Rand có bất kỳ phản hồi gì không?
Your Honor, the failure to appear was 6 years ago. He's been unemployed for 2 years. I think a $4,000 bond is going to be too high for Mr. Nguyen to bond out.
Tôi nghĩ ông ấy đã không có việc làm và 2 năm nay ông không có việc làm. Cái số tiền 4.000 đồng tại ngoại thì nó hơi quá cao.
I think a lower bond on that charge, perhaps 1,000, and then the stress that can't possess weapons or ammunition, bullets.
Tôi nghĩ là nên giảm số tiền tại ngoại xuống 1.000 đồng và đồng thời đưa ra các điều kiện là phải giữ các cái vũ khí hoặc là đạn.
That's all.
Chỉ có bao nhiêu đó thôi.
All right, thank you both for the arguments.
Cảm ơn cả hai cho sự tranh luận này.
I share the state's concern. However, with the out-of-state record and the alien inadmissibility note in his record,
tôi không có thấy những cái tiểu sử của ông ấy ở ngoài tiểu bang được lưu trong hồ sơ.
I'm going to stay the bond at $4,000.
Tôi vẫn giữ cái quyết định số tiền tại ngoại là 4.000 đồng.
Sir, you can't possess any weapons, firearms, or ammunition.
Và ông không được sử dụng hoặc là tàng trữ bất kỳ các loại vũ khí hay đạn dược nào hết.
And in 21 MO 1306, you're here charged with violating state misdemeanors.
Và hồ sơ 21 MO 2106, đây là tội nhỏ.
There is probable cause.
Và có thể ông phải trả chi phí.
I'll appoint an attorney to represent you in that case as well.
Tôi sẽ đại diện một luật sư để đại diện cho ông cho hồ sơ đó.
However, Mr. Brands, I'll treat that one as subsidiary and the bond will be $100.
Và với cái tội đó thì tiền thế chân tại ngoại là 100 đồng.
Thank you.
All right, good luck, sir.
Thank you.
Yeah, chúc ông may mắn.
I believe that's all we have for the interpreter at this time.
Okay, thank you for using our service. Have a nice day.
Thank you, you as well.
Thank you.
Please tell me your name.
Randy Sogero.
Sir, you're here in 21 CF 14421 because a warrant was issued for your arrest, charging you with burglary with a battery, grand theft from a dwelling, and criminal mischief. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Wait. Do you have an attorney?
Yes, ma'am.
You do have an attorney. Let me see if anyone's on the line.
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
I'm asking my JA. Hold on one moment. I just want to I'm not appointing the PD in this case, and I just want to make sure if your attorney was intending to appear, we get them on the line. Do we have two more people back there? All right, can we do their cases and we'll bring him back in. I just want to make sure we give his attorney the opportunity. Oh, that's why, because you were a loose though. It's your personality's fault. It sounded like that. Please tell me your name.
Casey Smith.
You're here in 21 CF 13477 because a warrant was issued for your arrest, charging you with burglary of a dwelling with assault or battery, domestic violence. Another judge has already found probable cause. I'll appoint an attorney to represent you. Good afternoon. Did you wish to testify today?
Yes.
Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give shall be the truth, the whole truth, so help you God?
I do.
Please state your name for the record.
Amanda Harwood.
I'll ask if the prosecutor has any questions for you.
Yes, Judge. Good morning or afternoon, ma'am. Can you please state your relationship to Mr. Smith?
Fiance.
Are you afraid of him?
No.
Has anything like this ever happened before?
No. It's a little out of, I don't know, it just doesn't seem appropriate.
If anything like this ever occurred in the future or anything more severe, would you feel comfortable calling 911?
Yeah, well, yeah.
And do you want to have contact with him while this case is pending?
Absolutely.
All right. Is there anything else you'd like to tell the court?
No, not that I can think of.
Thank you. Mr. Brantz, any questions?
No questions, Your Honor.
I'm sorry, ma'am. Can you tell me your name one more time?
Amanda Harwood.
Thank you. I'm reading while I'm listening to you. And Ms. May,
Yes, Judge.
do you see her name in this affidavit?
I have it within the actual discovery document. I don't see it within this actual affidavit.
The reason I'm asking is I don't see it in the affidavit. Is she the victim?
I have several, Your Honor, at least within the discovery document. A Lee Crosswaite, Miss Harwood, and then some juvenile witnesses.
Okay, so, ma'am, do you live at 2242 Cobblefield Circle?
That's my parents' address.
Okay.
Lee is my father.
All right. Thank you. Thank you for coming in for your testimony. Let me ask, does the state wish to be heard on bond?
Yes, Your Honor. At this time, given that it is a first-degree felony that's punishable by life, state's asking that you set it at no bond, pending an Arthur hearing downtown, where Ms. Harwood and the other witness, I believe Mr. Lee Crosswaite, can be heard. I understand the victim's testimony here today, or one of the victim's testimonies here today. However, I ask that this be set for an Arthur hearing downtown for a later time.
All right, Mr. Brantz, any response from the defense?
Generally, I would have no argument, but you do have a witness in this case in your discretion that you can question as to setting bond. Otherwise, he is entitled to that Arthur hearing with his attorney.
He is, and I do have one victim here, but I don't have the rest of them, and I find this affidavit a little bit confusing with respect to this witness. So at this time, Mr. Smith, you'll not have bond on this. It's a first-degree felony punishable by up to life in prison. Your attorney is going to file a motion and have that heard in front of the trial judge. However, even while in custody, you can't have any contact with the victim, any of the victims, or any witnesses in this case. Do you understand?
Yes, Your Honor.
All right. Good luck, sir. Thank you for coming, ma'am. Good luck. Please tell me your name.
Thomas Stewart Way.
21 CF 14622. You're here charged with possession of cannabis greater than 20 grams and possession of a controlled substance with intent to sell. At this time, I'm going to appoint an attorney to represent you.
Your Honor.
Yes.
As to, and this is mostly for bond purposes, as to count 2, I believe it was only cannabis that was alleged in the arrest affidavit. I don't know if controlled substances includes cannabis, but I know there's a possession of cannabis with intent to sell and deliver, so I don't know if that changes the bond amount. I believe a possession of cannabis with intent to sell or deliver might be a lower bond than a controlled substance possession.
It is a controlled substance.
I understand, Your Honor, but as far as when I see that, it's usually with prescription pharmaceuticals, things of that nature, which I guess medical marijuana could be also pharmaceutical, but more so like pills.
All right, but you don't have any arguments about probable cause?
No, Your Honor.
I reviewed it. I do find probable cause.
This was just to bond.
What says the state has to bond?
Your Honor, I believe I understand counsel's argument that generally when we see the possession of marijuana with intent to sell or deliver, it does usually come in with a lower bond. However, given that there is PC for this charge as well, I'll leave that bond determination within your discretion. There arguably was approximately 3 bags, all about a pound each. And Mr. Wood's history is rather short and rather old. It seems like his last conviction was 2007. So I'll leave that within your discretion, Your Honor.
All right, sir, I'll set your bond on count 2 at $5,000, count 1, $150. With special conditions, you can have no contact with any known drug dealers. You can't possess any controlled substance, which includes cannabis, without a valid prescription. Do you understand?
Absolutely, yes, ma'am.
All right, good luck, sir. His attorney is on the way. Do we have triplet? You refused? All right, so this is 21 CF 14617. I'll find his refusal a willing waiver of his appearance in court today. Mr. Brantz, I'm going to appoint your office in this case.
Yes, Your Honor.
Did you wish to be heard on any of these charges?
I had no PC challenges for this case, Your Honor.
There is probable cause. Does the state wish to be heard on bond?
Yes, Your Honor, given that count one is a life offense, state's asking that you hold no bond pending an Arthur hearing as to count one.
Any response, Mr. Brantz?
No argument. He is entitled to that Arthur hearing, though, with his attorney present.
All right, at this time, he'll have no bond on count one, $5,000 on count two, $5,000 on count three, $1,000 on count four. Cannot return to the scene for any reason, no weapons, firearms, or ammunition, no contact with any victim or witness. Are there any other conditions the state would request?
No, Your Honor, given that he's held no bond.
All right. Is he the only one we have left? All right, court is going to recess briefly because we have an attorney on the way. He's coming physically, he'll be present. So, Mr. Silguero, we'll come back as soon as your attorney gets here, okay? Yes, sir.
And, Your Honor?
Yes.
Unless the public defender is needed, may we be excused?
Yes. Do you have any other business before the court today?
Not from the defense, Your Honor, no.
All right. Court will be in recess, and you have a nice weekend.